The morning everything changed, I was sitting in the Adirondack chair on my back porch, watching a white-tailed doe pick her way through the mist at the edge of the tree line. I had my coffee. I had 40 acres of eastern Tennessee hillside rolling out in front of me. I had nowhere to be. Then I heard tires on gravel. I set down my mug and listened. 2 vehicles. I could tell by the cadence, one pulling in right behind the other, the way people do when they've driven somewhere together and planned it out. I walked around the side of the house and saw my son-in-law standing in my driveway next to a man I didn't recognize, who was holding a clipboard and a laser measuring device. My son-in-law smiled when he saw me. It was the kind of smile that arrives before the words, designed to soften whatever the words are about to say. "Morning, Everett," he said. "We figured we'd come out early, before the heat picked up. There's a facility in Knoxville that has an opening. The director said they can do a tour this week. We thought we'd go ahead and get things moving." I looked at the man with the clipboard. "Who is he?" My son-in-law's smile adjusted slightly. "Just a property consultant. Jolene and I thought it made sense to get a preliminary valuation while we're here, so we'd have a number in mind." I looked at my house. Then I looked at the property consultant, who had the professional posture of a man paid to be invisible during uncomfortable conversations. "He needs to get back in his truck," I said, "and so do you. But before you leave, I need you to come inside and show me whatever paperwork you believe gives you the right to stand in my driveway making decisions about my home and my life." The smile finally came down. "I need to back up and tell you who I am, because it matters to what happened next, not as a credential to wave around, but as context for why this story ended the way it did. My name is Everett. I'm 66 years old. For 28 years, I worked as a special agent with IRS Criminal Investigation, the enforcement division of the Internal Revenue Service that handles tax fraud, money laundering, and financial crimes. My unit specifically handled asset concealment cases, people who hid money, moved money, and used legitimate instruments to accomplish illegitimate ends. By the time I retired, I had worked more than 140 federal investigations and testified as a witness in 34 criminal trials. I retired 3 years ago and moved to this property in Sevier County, Tennessee, a house my wife Iris and I had bought together in 2019, 2 years before her diagnosis. We planned to spend our retirement here. I was going to build a woodworking shop in the back barn and restore the 1967 Airstream land yacht we'd bought at an estate auction the summer of that same year. Iris had already drawn out a hand-lettered route itinerary for a Blue Ridge Parkway trip, start to finish, with campsite names and distances measured out in colored marker. She died 14 months after her diagnosis. The Airstream sat in the barn. My daughter is our only child. She was 41 when all of this happened. She married my son-in-law 9 years ago. He was in commercial development, which he described with the confident vagueness of someone who has learned that specificity invites questions he'd rather not answer. Iris never warmed to him. She told me once, about 2 years into their marriage, that he paid attention to rooms the way she paid attention to prices, constantly, reflexively, and with an eye toward value rather than experience. I noted it. I didn't act on it. After Iris died, my daughter started calling more. Monthly visits became more regular. About a year before the morning with the trucks, she began arriving with folders. "Just estate planning, Dad," she told me the first time. "You really should have this sorted out." She was right that I hadn't updated my estate documents in several years. She brought them to the kitchen table with the ease of someone who had walked through these motions before, pointed to signature lines while talking about other things. How her youngest was doing in school, whether I'd had the water heater checked. Wasn't the light in the kitchen looking a little yellow? I signed. I was a federal investigator for nearly 3 decades. I know what you're thinking. I've thought it too. But there is a specific kind of trust that lives below your professional instincts, protected from them. It's the trust you carry for a person you held in your arms the day they were born. It doesn't disappear because you spent your career watching people steal from each other. If anything, it goes deeper, because you've spent your career watching other families collapse, and you've quietly, privately insisted that yours is different. That insistence is what my son-in-law was counting on. Inside my kitchen, at the same table where my daughter had been presenting me with documents for 12 months, He laid out 2 papers from a manila folder. The first was a durable power of attorney for healthcare with my signature on it, dated 9 months ago. It named my daughter as my healthcare proxy and granted her authority to make placement and residential decisions on my behalf in the event of documented cognitive decline. The second was a letter on the letterhead of a Dr. Kenneth Finney, a geriatric psychiatrist practicing in Nashville. It stated that following a clinical evaluation conducted 6 weeks prior, I had demonstrated deficits in executive function and short-term recall consistent with early-stage cognitive impairment, and that independent living in a remote rural setting posed increasing risk to my safety. I read both documents carefully, then I set them face down on the table. I have never met Dr. Kenneth Finney, I said. I have never been evaluated by a psychiatrist in Nashville or anywhere else. And I spent 28 years building the kind of paper trail that ends careers, so I'd encourage you to think carefully before your next sentence. He began something about my welfare, about how much my daughter and he loved me, about how they were only trying to do right by me. I held up one hand. My daughter, I said, is not in this room. She was standing by the sliding door to the back porch. She had been standing there since we came inside. She had not looked at me once. Jolene, I said, look at me. She did. Her expression had the quality of someone who has been holding something heavy for so long that they've forgotten what their face felt like without the weight. I need you to think very carefully about how far into this you've allowed yourself to go, I said. Because there's still a direction out of this that doesn't end with a federal charge. But that window closes quickly. She looked away. I asked them both to leave. After they were gone, I sat at my kitchen table for a long time without moving. The mist had burned off the hillside, and the tree line was coming up green and clear. The barn was visible from the window, the Airstream's aluminum nose just catching the morning light through the open doors. Then I picked up the phone and called my old colleague Monroe. Monroe had retired from IRS-CI 2 years before I did. He spent the first year of retirement consulting for a federal task force on elder financial exploitation, which turned out to be a second career in the shape of a transition. He now worked with a network of elder law attorneys across the Southeast and had more practical knowledge of the overlap between financial fraud and family law than anyone I knew outside a courtroom. He answered on the second ring. I gave him the full picture. When I finished, he said, "You still know how to read a financial disclosure?" I never stopped. "Then you're going to be all right," he said, "but move fast. These things get complicated once documents land in front of a judge." He gave me 2 names. The first was an elder law attorney in Knoxville named Declan. Mid-40s, 18 years of practice in family and probate law, had handled 11 contested guardianship cases in the past 4 years and won 9. The second was a woman named Opal, a former state securities regulator, who now ran a financial fraud investigation firm out of Chattanooga and contracted with attorneys across the region. I called both before dinner. Declan got me in the following morning. He was direct and organized in the way of someone who has sat across from enough frightened older adults to understand that clarity is its own form of reassurance. He read through both documents carefully, spending more time on the psychiatric letter than the POA. "Dr. Kenneth Finney," he said, studying the letterhead, "do you want me to have this verified before we go further?" "I assumed you would." "Good." He set the documents flat and looked at me. "The healthcare power of attorney is the more immediate concern. Even if the psychiatric letter is fraudulent, a signed POA for healthcare with your signature creates a legal instrument that can be acted on, and has been." He paused. "They submitted a placement inquiry on your behalf 3 weeks ago to a care facility in Knoxville, using the POA as authorization. The facility has a bed reserved under your name." I hadn't known they'd gone that far. "If the letter is forged," Declan continued, "then we have document fraud, and the POA signed under false pretenses is voidable. But Everett, if this is what it looks like, there's almost certainly more. These arrangements rarely stay contained to 2 documents." He was right. I met Opal at a coffee shop in Maryville 2 days later. She was 58, with close-cropped silver hair and the particular patience of someone who has spent decades reading numbers that weren't meant to be read. She listened to the entire timeline without interruption. When I finished, she slid a notepad across the table and asked me to write down my financial institutions and account numbers. "I'll have a picture for you in 48 hours, she said. She called in 36. "Your son-in-law's development company is called Ironwood Development LLC, she said without preamble. Registered in Tennessee 14 months ago. They have 2 commercial projects, one in Gatlinburg, one over in Jefferson City. Both are in default. Total outstanding debt is approximately $710,000, split between a private lender in Atlanta and a construction bridge loan through a regional bank in Knoxville." I watched a hawk work the far ridge in slow circles. "The bridge loan," she said, "comes due in 62 days. The lender has already sent a formal demand letter. Your son-in-law personally guaranteed it." She paused. "There's more. 8 weeks ago, a mail forwarding request was submitted from your address to a P.O. box in Knoxville, registered to your son-in-law. The request went through. Any correspondence sent to your home has been redirected since, including a notice from Lincoln Financial, your annuity provider, that a beneficiary change request was received and flagged by their fraud detection system. Someone attempted to change the primary beneficiary on your annuity from a Veterans Scholarship Foundation to your daughter. The request originated from an IP address not associated with any of your registered devices. I already knew the shape of the thing. I'd built enough cases to recognize the architecture when the facts started clicking into place. But hearing it laid out sequentially, that is different from understanding it in theory. "Current property value?" I asked. "Comparable lakefront properties in your area of Sevier County are ranging between $890,000 and $1.15 million, depending on acreage and dock access." She let that sit for a moment. "They've also been in contact with a Knoxville real estate brokerage about listing a rural lakeside property. The inquiry came through Ironwood Development." I thought about my son-in-law on his last visit, pausing in the barn doorway, asking whether the Airstream was insured separately from the main property. I thought about the way they arrived together for those document sessions. My daughter managing my attention, while he moved through the rooms, pausing in each doorway with the quiet, systematic attention of a man taking inventory. They had not been worried about me. They had been pricing what I owned. That evening, I went out to the barn and stood beside the Airstream for a while. The exterior had oxidized in patches. The interior still had the faded cushions it came with, and Iris's hand-lettered route map was tucked into the pocket of the driver's visor, exactly where she had left it the week before her diagnosis. I hadn't touched any of it. I ran my hand along the trailer's flank. Cold aluminum, the seams clean and precise the way they were made in 1967. Some things are built to outlast what you intended for them. Then I went inside and called Declan. The investigation moved quickly. Declan's office confirmed that Dr. Kenneth Finney was a licensed geriatric psychiatrist with a legitimate practice in Nashville, but had never treated me, never billed my insurance, and had no record of any evaluation matching the letter's stated date anywhere in his system. His practice manager was immediately cooperative. Dr. Finney himself was angry in the controlled, professional manner of a physician who takes the integrity of his name very seriously. He agreed to provide a sworn affidavit and filed a complaint with the Tennessee Department of Health within 48 hours. Declan filed for a civil injunction to block any property transfer and formally challenged the healthcare POA. He simultaneously referred the criminal evidence, the forged letter, the mail forwarding, the attempted beneficiary change, to the district attorney's office. What came next I had watched from the other side of many tables over the years. When people are caught, they don't stop, they accelerate. The part of them that believed the plan was sound, that they were simply smarter than whoever stood between them and what they wanted, doesn't shut off when they're identified. It redoubles. My son-in-law left 3 voicemails in 4 days. The first was conciliatory, the second was wounded. The third reframed everything as a misunderstanding produced by my own paranoia, and I noticed he never once used my name in any of them. Just you and the situation, the language of someone managing a variable rather than speaking to a person. I forwarded all 3 to Declan. Opal called during the second week, with one final piece of the picture. "The bridge loan," she said. "Your daughter is a co-signatory. Her name is on the account. She carries personal liability for the $710,000. She wasn't a bystander who'd been pulled along. She had skin in it. I sat with that for a long time after I hung up. The grief and the anger are different things, and I was moving through both of them at different speeds. The way you do when the facts are clear, but the meaning of them is still being processed somewhere underneath the facts. The civil hearing was on a Thursday morning at the Knox County Courthouse. I wore a gray suit I'd last had on while testifying before a congressional subcommittee. I drank my coffee watching mist move through the tree line and drove downtown with my briefcase. My son-in-law and my daughter arrived with an attorney named Blevins, a man in his late 40s who carried himself with the practiced aggression of someone who had built a career on the assumption that volume and confidence are the same quality. He found me in the corridor outside the courtroom while Declan was reviewing notes nearby. "Mr. Everett," he said, extending his hand, "I think there may be a path to resolving this without." "I spent 28 years in federal financial crimes," I said. "I know what a pre-hearing settlement conversation designed to make evidence disappear looks like from the inside. I'm not settling." He put his hand down. The hearing lasted nearly 3 hours. Blevins presented photographs of family occasions. My daughter's wedding, a Christmas dinner, a picture of my son-in-law, and me fishing 2 summers ago, both of us smiling. He talked at length about the loving concern of adult children watching an aging parent struggle, and the difficult decisions that love sometimes requires. Then Declan presented the record. The sworn affidavit from Dr. Finney confirming he had no record of ever evaluating me, had never met me, and that his letterhead had been used without authorization on a fraudulent document. The forensic document analysis, prepared by a certified examiner, who confirmed the letter was inconsistent with Dr. Finney's practice management system and contained metadata indicating it was drafted on a device not registered to his office. The mail forwarding records diverting my correspondence to my son-in-law's P.O. box. The attempted beneficiary change with IP address logs showing a device not registered to my accounts. The financial profile of Ironwood Development, the defaults, the personal guarantees, the demand letter with its 60-day clock, and finally, a series of text messages obtained through civil discovery between my daughter and my son-in-law, spanning 13 months. The judge, a woman in her early 60s with the composed precision of someone who has processed a great many human disasters across that bench, read through the text thread in silence. I watched her face across the courtroom. There were a lot of messages. They told the story without ambiguity. My son-in-law's escalating panic about the debts, my daughter suggesting the property as a solution, first framed as a hypothetical, then sharpened into a plan, his research into Tennessee conservatorship law, her identifying which documents I'd already signed and which still needed to be obtained, his asking whether memory care facilities in the Knoxville area had availability, her sending him a link to the facility with the note, "Cheapest option in the county, it'll do. Once he's settled in, he won't be thinking about the house anyway." I had read those words 3 times the night before, sitting at my kitchen table with Declan's discovery packet open in front of me. Once he's settled in, he won't be thinking about the house anyway. Each reading, something tightened behind my sternum in a way that had nothing to do with anger and everything to do with the specific grief of being seen as someone who had already stopped mattering. But there was another message. 11 months ago, before any of the documents had been obtained, before the plan had taken its final shape, my daughter had written to him. "Dad spent 30 years catching people who stole from strangers. He never once thought to look at the people who loved him." And my son-in-law had written back, "That's what makes it clean." The judge set the documents down. She looked at the 2 of them for a moment before she spoke, with an expression that had no warmth in it at all. The healthcare power of attorney was revoked in its entirety. The fraudulent psychiatric evaluation was stricken from all records. The injunction protecting the property was made permanent pending further proceedings. The placement reservation at the Knoxville facility was declared void. She looked at Blevins. "The conduct documented in these materials extends substantially beyond a civil family dispute. I am referring this matter in full to the district attorney's office for review of potential criminal charges, including document fraud, elder financial exploitation, and mail tampering." She paused. "I'd suggest your clients seek criminal defense representation this afternoon." The gavel came down. I stayed in my seat while the room cleared. Out in the corridor, I could hear voices. Blevins is raised. My son-in-law's lower and harder. My daughter's, not at all. I passed her on the way to the elevator. My son-in-law had already moved ahead, phone already out. She was standing in the middle of the corridor, like someone who had forgotten which direction led out. She looked at me, and something moved across her face that I couldn't fully read. Part of it looked like she was forming the words for the thing you say when you've used up all your explanations. But the regret hasn't run out. I didn't stop walking. The criminal case moved faster than I'd anticipated, which Monroe told me was consistent with Tennessee's elder exploitation statutes. The district attorney's office had the evidence organized and trial ready before I'd finished settling the civil matter. My son-in-law was charged 7 weeks after the hearing. Document fraud, elder financial exploitation, mail tampering, and fraudulent use of a financial instrument in connection with the annuity beneficiary change. The exploitation charge carried an enhanced penalty because the scheme targeted property valued above $500,000. He received 3 years in state prison. Restitution was ordered to the Atlanta lender and the Knoxville bank, both of whom had filed their own complaints once the case became public record, which it did quickly and thoroughly. My daughter entered a plea agreement. She cooperated with the prosecution, provided detailed testimony about the planning and the timeline, and identified several communications that the investigators had not yet located. In exchange, she received 18 months of supervised probation, 250 hours of community service, and mandatory financial counseling. The sentencing judge noted on the record that her cooperation had been material to the conviction, and that her participation in a scheme targeting her own father represented a betrayal of the most foundational kind of trust the court had encountered in family proceedings. I was not there for her sentencing. I had decided that some things are better not witnessed. Not because they don't matter, but because your presence at certain moments changes what those moments mean. That evening, Monroe came out to the property. We sat on the back porch until past dark, which was the first time I'd had company out there since Iris died. We talked about the case for a while, then about other things. Former colleagues, the way financial crime patterns had shifted in the years since we'd both started out, whether either of us had gotten any real fishing in lately. At some point, he asked if I was doing all right. I thought about it the way I try to think about any question that deserves an honest answer. I think so, I said. Something's been cleared out. It doesn't feel like a win. It feels like accurate, like the record now reflects what happened. He nodded. He'd worked long enough in this field to understand the difference between those two things. After he left, I went out to the barn. 3 weeks earlier, the week after the civil hearing, I had finally started working on the Airstream. I wasn't sure why then, exactly, except that it felt like the right direction to point myself. I stripped the oxidation from the exterior panels, replaced the wheel bearings and the corroded wiring in the interior lighting, sourced new cushion fabric that matched the original pattern as close as I could find. The work took longer than I expected in some places and less time than I'd feared in others. That last evening in the barn, I fitted the final cushion and wiped down the aluminum countertops and replaced the glass in the small framed photograph of Iris and me that I had kept on the workbench the entire time I was working, not because I needed to look at it while I worked, but because I didn't want to put it away. I set it back on the small shelf above the dinette where she would have put it herself. Then I hitched the Airstream to my truck, pulled it slowly out of the barn for the first time in 2 years, and parked it in the driveway with the nose pointed east. I climbed into the driver's seat and sat there for a while, with the engine off. The mountains were going dark in the way they do in Tennessee. Not all at once, but in layers, ridge by ridge, the deeper hills holding the light a few minutes longer than the nearer ones. The Airstream's exterior caught the last of it. I reached up and pulled the hand-lettered route map from the visor pocket. Iris had used green marker for the campgrounds and red for the overlooks she most wanted to stop at. The paper was soft at the creases from 2 years folded in the same position. I spread it open across the steering wheel. 28 years of federal service taught me that fraud succeeds because people believe that love is insulation from scrutiny. The fraudster's essential calculation is that the mind goes lazy when the person handing you a document is someone you trust entirely, and sometimes they are right. The professional reflex that kept me sharp through 140 investigations did not protect me from 12 months of patient erosion by my own daughter, because trust and scrutiny come from different parts of who you are. And the one you turn off when someone hands you a pen across a kitchen table is not always the one you intend to turn off. What they didn't account for was that the same mind that let the trust in builds the case when the trust is broken. I don't say that with any satisfaction. I say it because it's the most accurate thing I know about what happened. The map was a good one. She'd done her research, marking all the best stops, all the long views. It was still a good plan, even now. Some things take longer to get to than you intended. That's not a reason to leave them folded in the dark. I started the truck.